Ready, start. In order to avoid the same, some public servants adopt several methods of collection of bribe amount instead of receiving the bribe amount with their hands and keeping the same in their pockets. One such method is directing the victim witness to drop the tainted currency into table drawer or into briefcase or into any other place to which the accused alone has got accessibility so that he can pick up the said dropped amount conveniently at a later point of time. If such methods are adopted by clever public servants, then the routine method of phenolphthalein powder and sodium carbonate solution and turning hand fingers as well as pockets of the accused into pink becomes not possible from the fact that hand finger rinses of the accused not turning pink in sodium carbonate solution, it cannot be taken as a circumstance which disproves the prosecution case. Though investigating agency may be unsuccessful in nabbing the culprit by adopting such method in certain cases, the prosecution is not precluded from proving that the accused demanded and accepted bribe amount by leading other evidence. We are unable to appreciate the reasoning adopted by the High Court in this regard. In the first place, the negative result of the single inverted comma hand was single inverted comma close test was only one of several suspicious circumstances considered by the trial court, not the first or most determinative one. More importantly, it is not the case of either side that the appellant physically handled the tainted notes, and the same has been accepted by the High Court. The prosecution maintains that the notes were dropped into the drawer at the appellant's instance, while the defense asserts that they were placed there without his knowledge. For either side, the single inverted comma hand was single inverted comma close test, and the negative result thereof is of no consequence as it cannot advance the case one way or the other. What is troubling is that the High Court has nevertheless seized upon this circumstance and gone on to attribute wrongful intent to the appellant. We take this opportunity to reiterate that suspicion, however strong, cannot take the place of proof. The statutory presumption under Section 20 of the PC Act is not automatic and arises only once the foundational facts of demand and acceptance are proved. For an offence under Section 7 of PC Act, the demand of illegal gratification is a sine qua non to prove the guilt. Mere recovery of currency notes cannot constitute an offence under Section 7 of PC Act unless it is proved beyond reasonable doubt that accused voluntarily accepted the money knowing it to be a bribe. The proof of acceptance of illegal gratification can follow only if there is proof of demand. In the instant case, too, the sole basis of the prosecution to prove demand and acceptance is the narration of the complainant, a close scrutiny of which reveals serious infirmities. At the outset, the complainant has no proof other than his own oral statement that he visited the appellant on 25/9/1997.